Albertson at Albertson and Davidson. In this video, I'm talking about trust abuses, and I'm talking in particular to the have-nots. These are the people who have been totally disinherited. So a trust amendment has come along and you now are receiving zero out of the trust or estate. In our last video, we discussed some of the challenges facing have-nots. In this video, I want to talk about how do you make things right. So you're going to have to file a lawsuit to challenge the validity of the trust amendment or trust document, whichever it is. And you're going to have to find evidence to support your legal claims. Your claims are probably going to be based on lack of capacity and undue influence. Well, both of those claims have an aspect where we look at the settlor and we ask, is this person either lacking capacity or are they vulnerable to undue influences? Both of those issues means that we have to go and look at their medical records. So one of the first things you need to do is secure the medical records for the decedent. That's usually done through a subpoena once you have your lawsuit filed. The next thing you're going to need to do is get a medical expert to look at those medical records, because somebody's going to have to give an opinion in court. It can't be you. You can't just submit the medical records to the court and expect the court to read them. They're not going to do that. Plus, most of the medical records contain hearsay information. So you're probably going to need a medical expert on your case. The next thing you look for is treating physicians. So there could be a physician who actually diagnosed a problem with the decedent, such as dementia, Alzheimer's, stroke, something like that. You're going to need to depose that person, get information, and try to secure their testimony to see, well, what was your opinion of the decedent when you did your examination? And how severe was their dementia? What type of strokes did they have? And how did that affect their cognitive ability? These are all important factors in your case. The next person we're going to look to is the drafting attorney. If an attorney drafted the trust amendment or the new trust, we want to get their deposition as well and their testimony, because we want to know, what process did you use? Did you evaluate the decedent to see if they were lacking capacity or acting under undue influence? And did you ever meet and talk to them about their desires? There's times when people will do an estate plan without ever meeting with an attorney, even though it's technically attorney drafted, because the attorney might just email it to them or something like that. So you have to get down and really get the facts of what's going on there. And then lastly, there might be any number of fact witnesses, neighbors, friends, caregivers, people who were around the decedent, and these people would also need to be deposed. So there's a lot that has to go into your case. And if you're not working your case, if you're not doing the depositions, serving the subpoenas to get medical records, making sure that you get testimony locked down, then you're really not going to be prepared for trial, number one. And number two, you also are not going to have ammunition to use if you end up going into something like a mediation or settlement conference. Because when you're in a mediation or settlement conference and you have this deposition testimony, it can work really well to help the other side see that they need to give you a favorable settlement if they want to get out of the case. So the name of the game for the have-nots on trust disinheritance cases is you got to put in the work. You got to roll up your sleeves and you got to get to work. And there's a lot of work that has to be done. The sooner you go to it and the faster you get to these items like depositions and subpoenas, the better. Because keep in mind, our legal system moves very slowly. And so the average case is going to last between 8 and 18 months. And if you can get your case resolved either through settlement or trial within 8 to 12 months, that would be lightning fast in our legal system, just because that's the way that it works. So you got to put the work into your case if you want to get something out of it. Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.